Thank you, Counsel.
Thank you.
Next case on the docket is Ramnarain versus ProNet.
May it please the court.
Go
My
ahead
name
and
is
let counsel get set up there before you get started. Go ahead.
My name is Christopher Palermo, and I am attorney for the appellants in this matter. I want to reserve 5 minutes, roughly, for my rebuttal. With this case, the first comments I want to make on this case is that where we believe that the trial court went wrong was really an act of judicial activism. This trial court did two things. First and foremost, they made the assumption, they went ahead and looked through the pleadings and what were potential factual issues, and they made the factual determination that the engineer of record who assists the insurance company and the homeowner in determining whether or not there's sinkhole loss at a home, they went forward and made this determination that, oh, this is nothing but a mere consultant. And that was, right off the bat, a very activist position. The court looked at the pleadings where clearly there was an issue as to that. There's a statutory scheme that clearly contradicts that particular conclusion, and they went ahead and did it anyways. And they created the court created a category that said, if you do no work on a property, no physical work, therefore you must be nothing but a mere consultant, therefore you have no duty. No duty in contract, no duty in tort, no duty at all. And that is so 180 degrees opposed to what the actual law is. We have a statutory scheme that, in point of fact, says something very different. The statutory scheme says that the engineer of record, in fact, has multiple duties of reporting to not only the insurance company, but also the homeowner. It's right there.
How did the homeowner rely on or how did you plead that there was reliance by the homeowner on the engineer's report?
Well, Your Honor, I'll answer it this way. First and foremost, this case was dismissed with prejudice, so we didn't, let's just say we had an imperfection in the pleading on the issue. We were never given an opportunity to remedy that. But to answer the question, the homeowner and the insurance company contractually agreed to rely upon the engineer of record's final determination. That's a matter of the contract. The contract that's also buttressed by the statutory scheme.
Well, but the contract has all sorts of provisions in it. I mean, if it's like most homeowners' policies, and I know the statute talks about neutral evaluations. I mean, there's a whole series of procedures, but, you know, again, I just want to focus on how did your clients rely? So let's assume, just for the sake of discussion, that I agree with you that whether or not the engineer did any work on the property is really an irrelevant consideration. But, you know, the contract is between the insurance company and your clients. And so let's assume that the engineer is 180 degrees wrong. He's absolutely wrong, does a terrible job, and the insurance company turns him down on the claim. Why isn't your remedy simply your breach of contract claim against your insurance company? What difference does it make? What happened in the underlying claims process? And how did your clients particularly rely to their detriment on that engineering report? What did they lose by relying on it? I mean, they still had their remedy if they were right. If it's a single loss, they sue the insurance company and they get their money.
Well, it's not, and I respect the question, and I think that goes to the crux of the matter. But it's not that easy. The clients actually not only rely because they're not engineers. The engineers prepare a report. Here comes a professional, gives you a report after they came to your home and interviewed you and things of that nature. So we pled, of course, that the fact that a professional engineer came on behest of the process was reliance, and that ultimately is a jury question. We believe we pled it with sufficient particularity.
I mean, did you say anything more than we relied on the report?
Well, I believe.
And wouldn't it have to be detrimental reliance? I mean, where was the detriment when they didn't lose their right to sue the insurance company?
The detriment comes here. The report is presumed correct. That's where the detriment comes in.
What's the nature of that presumption? Is it a vanishing presumption, or is it some sort of evidentiary presumption that you have to rebut?
Well, it is a vanishing presumption if you're willing to go into your own pocket and hire another engineer. So
Wouldn't you have to do that to bring in this suit anyway? If you're gonna argue that this engineer didn't do it right, and you want to proceed with this lawsuit, aren't they gonna have to go into their pocket the same way to hire an expert?
Well, so what see, this goes to the heart of you have multiple defendants here, okay? So in this particular case, the burden of proof is different, the causes of action are different. When you are going in a lawsuit against your insurance company, and there's that presumption of correctness, but more so than that, it is a vanishing presumption, but in an insurance contract, the defendant is the insurance company. I cited the case that said, State Farm versus Kalia, where the second DCA said, well, if the insurance company relied on the engineer of record, what did they do wrong? That's the key, because you're suing the insurance company.
Well, but if you sued the insurance company and you proved that their engineer got it wrong, and you prove that it was sinkhole damage, then you get a recovery from the insurance company, right?
Under a theory of breach of contract.
Right.
The insurance company, every day in these trials, loves to throw their hands up like they're impotent, like Pontius Pilate, and they say, what have we done wrong? What have we done wrong? It's that person's fault. It's not our fault. So, ladies and gentlemen of the jury.
So you have a breach of contract count, but your argument, you also want a bad faith, a first-party bad faith count? So you
I'm
get,
not
is that what
asking
you're
you.
arguing?
No, that's not my argument.
Okay.
I'm actually here today to say the insurance company did nothing wrong. I'm here today to say the
Well,
insurance
if
company did nothing wrong.
if there was sinkhole damage, then the denial of the claim is something that was wrong, right? You
Not if
can, you
you
can
trust.
sue them for denial of the claim, whether it was in good faith or not. If you prove there was sinkhole damage, you would get a judgment against the insurance company, right?
Under the rubric of a breach of contract.
Okay, what's the problem with that?
Because the true party at fault here, is the engineer who did shoddy work. The engineer
You
did
can get
shoddy
your
work.
recovery from the insurance company, and you can even get your attorney's fees there, right? Because you're the insured under a policy.
But my question is, and has always been, and it's not directed towards you, my question is just directed towards what we know of the American jurisprudence system. Why is somebody who clearly is a defendant under 552 of the restatement of torts getting such an immunity? Why are we judicially creating an immunity for a party? Where in this country have we ever said, oh, just because you can sue him, you can't sue him? They're both wrong, but don't sue him.
But
It's an immunity.
552 has two primary elements. That the defendants owed your clients a duty, and that they relied on the defendant's report as part of that transaction. And I'm not sure that I see either of those two met. I mean, what is it, other than the insurance contract between the insured and the insurance company, what creates a duty under 552 between the engineers and your clients?
Well,
And
Florida,
how is the reliance there? I understand what the statute says, that it's presumed correct. But all that does is, it's a vanishing presumption. I mean, we're not talking bad faith. So if your clients, as Judge Palmer points out, I don't see how you can pursue this lawsuit without having an engineer come in and say they did shoddy work and they were wrong.
well, that's what we've already done.
Well, then
But-
why
but
don't
it's
you
more
just do
so,
that in the
they did
underlying?
not-
Why
they-
don't you do that in a breach of contract lawsuit, and you get your attorney's fees if you prove it?
Well, because we're going back to the argument that, okay, maybe we could prevail against an insurance company, possibly so. But why because there's another defendant, does this exonerate this defendant?
How is this different? I mean, there's a whole series of cases against, accountants, and when accountants are liable for doing shoddy work on balance sheets and the bank makes a loan and then they otherwise wouldn't have done it. There's a whole series of cases against attorneys where somebody claims to be a third-party beneficiary of some transaction, and most of those cases, there are some outliers on special facts, but almost all those cases don't support a claim under 552. I mean, they generally say, we're looking at who is the client. And if your client is, this person, they can sue you for essentially professional negligence, but not everybody else who might be incidentally affected by that transaction. Why is this any different than that myriad of lawsuits out there dealing with accountants and architects and lawyers?
Well, I think that you hit it on the head. This is a special circumstance. This is not a mere consultant. This is not a mere consultant in privity with one party. There were cases raised by opposing side where, somebody hired a consultant, they looked at it, they said, you know what, I won't pay this claim. But it was a report that was for their eyes only. The law is quite consistent. When that report leaves the auspices of for your eyes only, then you do open up. It does become a special circumstance. Absolutely. Statutorily, let's go to 552. They fall right under both number 1 and number 3. This is somebody who, an engineer of record, is not just behaving just in the course of a normal business transaction. They're actually operating under public duty.
Well, but those cases generally deal with where engineer designs this building, and while you're making an oral argument, the ceiling falls in on you. And there, the cases say, yes, they owe a special duty because there is a public duty owed to engineer the building properly. This seems to be substantially different than that sort of engineer liability.
Aren't they, though? Let's go to 5521. Aren't they providing information for the guidance of others in the business transaction? They're not just providing information for the guidance of the insurance company in the business transaction, by no means. They're also providing this information for the guidance of the homeowner. The homeowner's sitting there really at a disadvantage. Here comes the engineer of record in a royal robe, and it gets delivered to their house. This is so different than any of the normal consultant behaviors. This is so different. These are questions of fact for a jury. It's clear. Why is this industry and this particular party entitled to an immunity that the legislature did not create?
Let me ask you a hypothetical. Let's assume it was a medical malpractice case, and the plaintiff has to provide a statement from a doctor before he can file suit that there was malpractice here.
Well, it's not that, but I could if I needed to, I could.
Well,
I do medical malpractice.
would a defendant doctor be able to sue a doctor who provided an opinion to the plaintiff that there's a basis to sue if he said that doctor did it wrongly?
Factually very different. Factually very different. This is so factually different. This engineer of record's not somebody that's performing their services in anticipation of litigation. They're providing their services in the chain in the chain of the business transaction. They step into the picture not even contemplating litigation.
What's your client's damages?
My
Allegedly.
client's damages are that, number one, when you get outside of the date of loss, okay, this is argued all the time in sinkhole trials, and you start to create and you start to marshal the evidence, one of the first defenses that the insurance company will say with all this information was gathered outside the policy period. So we in fact do not know if as the date of loss, this was the condition. And that's a hard one. That's a hard one. So what happens is this, and I'm gonna because I'm almost into my rebuttal time. What the engineer of record has done, let's talk reality here. In order to curry favor, in order to get the business, they've gone in and done the equivalent of you going to the doctor with a chest pain. Doc.
Was that your allegation in your pleadings?
Absolutely it was.
That this was done to curry favor, et cetera?
Well, it's laid out. I mean, you don't want to put overly scandalous information, but we're here having a public policy debate because ultimately this is what this is all about. Of course. Of course. Let's talk realpolitik here. So what ends up happening is you end up going to a doctor, an elephant's on your chest. The doctor looks at your mouth, looks at your ears, looks at your nose, says, "You're fine. See you later, buddy." Because they don't want to put a claim in with the insurance company, or whatever their motivation is. This engineer of record did shoddy work, terrible work, and now they have put this homeowner behind the eight ball vis-a-vis the litigation against the insurance company. Absolutely. Absolutely. These are two very different litigations. And this defendant, this responsible party, why are they being given an immunity that the legislature did not intend them to have?
How are your damages any different against the engineer than they would be against the insurance company?
You could end up actually through damages, through that analysis, you could end up getting different damages. Absolutely. But the key is this: the theory of liability is different. It's easier. I'd rather have the party responsible sitting in that defendant's chair than a party that maybe is just sitting there that is maybe not as responsible. I don't think the insurance company is as responsible as the engineer. The engineer is
But,
wrong.
I mean, essentially your theory is,
I'm in my
that the-
rebuttal time. How do you want me to handle that?
go ahead.
Okay, I'll
let
come
you
back.
save your time.
Thank you. Give me one minute. I'm gonna stop.
Got a little over 3 minutes.
May it please the court. Good morning, Judge Palmer, Judge Higbee, Judge Orfinger. Judge Orfinger, this must seem a little bit like deja vu to you because you wrote the majority opinion in the Dingle case last year, in which this very central legal analysis was set forth.
You must have thought it was right if you're citing it. I don't even remember it basically.
Well, I honestly, it came to a conclusion that was not helpful, but the analysis was dead on for this case. It was completely different because it was a legal malpractice case, and so it had different facts, and you did reverse the trial court, which had dismissed a breach of third-party beneficiary case.
That was a will or trust case.
Exactly, Your Honor. It was, they were attempting to have some sort of conveyance of property, and you found that there were unique circumstances that took it out of the general rule. But let me just turn to that. And Judge, what you wrote on page 488 was, to assert a third-party beneficiary claim, which is what we have here, the complaint must allege, 1, a contract, 2, and this is what I'd like to focus on first, an intent that the contract primarily and directly benefits the third party, 3, a breach of the contract, and 4, resulting damage from the third party. And you cited the Coretta Trucking, Inc. versus Choi Lee Shipyards Limited case. 647 Southern 2nd 1028, which is the case that cited the most of any other case. And you noted a party is an intended beneficiary only if the parties to the contract clearly express, or the contract clearly expresses, an intent to primarily and directly benefit the third party or a class of persons to which that third party claims to belong. Now, we're going to set aside for the moment whether there was a contract, because Judge Orfinger, your comments and Judge Palmer's comments cast doubt upon whether there even is a contract to work with. There's all sorts of threads here in the insurance code and the restatement, but set aside for the moment whether there is a contract. Let's look at the second criterion, which is an intent that the contract primarily and directly benefits the third party. And the courts tend to try to make a distinction between whether there's an intent that the contract primarily and directly benefits a third party versus whether that interest is so remote and incidental, and if you fall in the second category, then you do not have a claim. Now, we contend, just so we're clear, there isn't even any evidence from the allegations of the complaint that there's anything even remote or incidental vesting third-party beneficiary rights. But the complaint said, and there are two complaints, complaint and amended complaint, because Judge Rogers gave him a chance to amend to get it right. In the first complaint, the contract was the report. Now, what was the purpose of this report? It was to assess whether there was structural damage under the sinkhole statute. Florida Statute Section 627.706 sub K. But what did the report say in it? The report said specifically, this report was prepared for the exclusive use of Universal Property and Casualty, and it is not intended for any other purpose. ProNet Group, Inc. assumes no responsibility whatsoever for the unauthorized use of this report by a third party. And another part of the report says, this report should not be considered a warranty or guarantee express or implied of any kind. Now, a contract that expressly provides that it's not for the benefit of a third party does not create rights in a third party as a matter of law. And I cited to you two cases, Venezia Lakes and Networkship, for that proposition. So in terms of the legal analysis, that's as far as Judge Rogers had to go. And he did, in his first order dismissing this complaint, he did cite to that premise. And he dismissed the complaint because he said there was no contract attached to the complaint, which was in violation of Florida Rule of Civil Procedure 1.350. And he said what was attached, and this is attached to both the complaint and the amended complaint, was the report. And that report expressly contradicted and undermined any third-party beneficiary rights in that document. Now, in the amended complaint, we have new allegations regarding the contract. The contract, by this time, has now transformed. And now it's an oral contract between the insurance company, Universal, and ProNet, my client. And it's to do work that ended up being documented in the report that you have before you as to whether there was any structural damage to the house. But again, this doesn't change anything in terms of the legal analysis because there's a Mount Everest-sized legal problem. Again, returning to Judge Orfinger's, his analysis in the Dingle case, number 2, an intent that the contract primarily and directly benefit the third party. Where is there any allegation that the oral contract primarily and directly benefited the appellants in this case? It's not in the contract because there are no terms to the contract, no conditions, no evidence of duty, of obligations, no consideration. It's just a comment that there was a contract and that it was not reduced to writing. They write that 3 times in the amended complaint. It's not reduced to writing. So where is there intent alleged anywhere in any of these complaints? Well, they go to section 522, the restatement of torts. And I have to tell you, this case has been like taking a walk down memory lane for first-year law school torts, and contracts. Because lots of theories have been tossed out, and unfortunately, none of them fit this particular case. I'm looking for 522, excuse me, Your Honors. Okay. It has in paragraph 76 of the amended complaint, he cites the restatement second of torts, section 522. Subpart 1 says, and I quote, "One who, in the course of his business, profession, or employment, or in any other transaction in which he has a pecuniary interest, supplies false information for the guidance of others in their business transactions, is subject to liability for pecuniary loss to them by their justifiable reliance upon the information if he fails to exercise reasonable care or competence in obtaining and communicating this information." And Judges Orfinger and Palmer, you have picked up on why this has no application, because there is no reliance. There's no reliance whatsoever on this document. There's no entitlement to reliance, and there's certainly no detrimental reliance.
How do you respond to the argument essentially that because there's a statutory presumption that the report is correct, that it's reasonable for the insured when he or she receives this report to say, well, that's what the engineer says, so I guess that's the way it is? I mean, isn't that at a very minimum the reaction that an insured has, assuming that they understand the statutory presumption of correctness, and it's coming from a licensed engineer, and they get the report and says it's not a sinkhole?
Well, Judge Orfinger, my opponent does make mentions numerous times about how these engineering opinions are cloaked in correctness, statutory correctness. But you point out yourself, it's a vanishing presumption. All they have to do is to have someone who is qualified, they're not qualified with all due respect unless they happen to be engineers, to look at it to say this is not right. They didn't follow the right procedures, or I disagree with their math, or whatever it is. And as soon as they come up with that opinion, poof, that presumption vanishes. So it's not anything that is that it somehow bestows upon them a cause of action, or it imputes a duty from that statute. And the next was the sinkhole statute itself, which is what we're talking about, Judge Orfinger. It is a statute which has requirements in it for any insurance company that wants to write sinkhole insurance in the state of Florida. They have to abide by certain methods to analyze whether structural damage was caused by sinkholes or whether it's caused by settling. Requires that the analysis be certified by an engineer and a copy provided to the insured. But there's no duty whatsoever that is stated in there or that could even be imputed from that. And so the only conclusion that can be reached is the one that Judge Rogers reached after one hearing and two complaints, that there's not a single allegation that remotely suggests that there's an intent to primarily and directly benefit the appellants. In fact, the report that they attached to both complaints specifically disclaims third-party rights in the contract. And if there's as you know, judges, if there's a conflict between what is attached as an exhibit and the allegations of the complaint, the exhibit controls.
You don't disagree that in some context, an engineer can be responsible to unknown third parties. If your client designed this building, did it negligently, and it fell in on my head, would I have a claim against your client?
You might. You might. It would depend upon how the contracts read and what were the relationships between the parties. That's what the courts look at. And also, quite frankly, from a practical reason, and we're going to get to this in a second, whether the injured party really is out of court if this is not allowed, if there's really no other redress. which we might as well talk about that now, and that is that for some reason, and again, both Judges Palmer and Orfinger asked questions about this, there are contentions in here that these people are out of court, that they have no other redress. That's simply not true. They have a bundle of rights that they can take advantage of. And it includes, but is not limited to, that they can elect to participate in non-binding neutral evaluation process for disputed sinkhole claims with their insurer as outlined in Florida Statute 627.7074.
I didn't understand their argument to be that they didn't have another remedy. I understood their argument to be, yes, we have other remedies, but that doesn't preclude us from this remedy. We should be able to pursue multiple remedies.
Well, if that's their argument, I didn't understand that, Your Honor, but if that is their argument, then it makes no sense. Because, as you said, what's the difference in your damages? If you're suing and you have structural damage that should be covered under a sinkhole policy, you have X number of dollars in damage,
Well,
correct?
irrespective, let's assume that the damages are identical. If they have a claim against, and I'm emphasizing if they have a claim against your client, isn't it within their right to pursue your client to the exclusion of anybody else that might be responsible?
If they had a claim, yes, Your Honor.
So the fact that their damages might be the same, I mean, if you and Joe Blow are both responsible, and I've got a claim against Joe, but I know that Joe is judgment-proof, I mean, I don't have to pursue Joe, I can just come after you.
Absolutely.
And so it really comes down to not what are the measure of damages, but do they have a claim against your client under either a contract third-party beneficiary or under 552?
Right. That is the issue, Your Honor. You've framed it, and the facts are very clear that they do not. Because, again, you have to have some evidence of intent. There's no evidence of intent. They want to...
Is it evidence of intent, or can it be inferred because your clients knew that the report would be disclosed to the insureds? And presumably, they understand that the insureds are going to evaluate that report and do something, either accept it, question it, or reject it. Is that evidence of intent, or at least subjectively evidence of intent?
Your Honor, we would contend that it's not even evidence of that would give these people, make these people an incidental beneficiary. It's just not enough there. The case that you wrote, the Dingle case, it was a case where there was a grantor that wanted to give property to a grantee, goes to a lawyer, says, make a quitclaim deed, I want to get this done. And they wrote up a contract, a legal contract. The lawyer blew it, allegedly. And after he died, they went to get their property, or they didn't, they had their property. It was contested and found that the quitclaim deed was invalid. So they looked, the court looked at, you looked at the relationship between the parties and said, this is different. Yet they're not in privity, they being the grantee and the lawyer who's getting sued in the law firm. But this is different because a lawyer that sits down and writes a document knows that this is the sole purpose for that document is to give it to the grantee. So the grantee has to be a third-party beneficiary. So we're going to allow this case to proceed on a third-party beneficiary status. None of those relationships are present here, none of them.
But you have a statute that creates a relationship in this case and requires that report to be done, and again, does clothe it with some, that it's proper, that it's been done right, that it's correct. So why wouldn't that be done for the benefit of, I mean, sort of stripping it away to basics? This is their home, and that report is being done on their home. So why is there not ostensibly some sort of benefit to the homeowner by virtue of the preparation of this report, especially when it's directed under statute?
Because, Judge Higbee, the engineers who did the report are mere consultants. And just like Judge Palmer said, if you accept their argument what you would do is you'd be opening up the floodgates of litigation. I know you hear that, and it's cliche, and I apologize for using it, but it really is, it applies here.
Who defined them as consultants? Where does that definition come from?
I guess it's a standard in the industry is that these were not people who were working on their property for the homeowner. These were people that were brought in and requested, apparently in an oral contract, according to them, to look at the property, look at the alleged damage, and say whether it's sinkhole damage under the statute. And again, if we go down this road, let's go to federal court. Under Rule 26, every expert has to file a report. And I can tell you that most of them, 95% of them, they say bad things about the other side. So does that mean that those experts can now get sued by the opposing parties? What's the difference? What's the difference between Judge Palmer's example, where you have a medical malpractice case, and the statute requires that you get an opinion saying that a doctor committed malpractice? Does that consulting doctor now, once he or she gives that opinion, are they subject to liability because it's inferred somehow? You make everyone a third-party beneficiary to every document. That's really what he's asking.
What's the basis of the trial court's conclusion that he writes there are two lines of cases, those in which the property is altered by the defendant and those in which, as is the case here, the defendant does not alter the property? What's the basis of that?
Honestly, I don't know. I looked at that, and we never discussed that. And I never...
It wasn't a position that you advocated?
No, sir. No.
Because I couldn't come up with anything that supported
I
that statement.
I didn't either, Judge. I looked at that, and I had another lawyer look at that, and I think what he means is sort of what we're talking about with Judge Higbee here, and that is, a consultant versus someone who's actually laying hands on the property and doing something to the property. And that the courts generally, shy away from finding negligence or allowing cases to go forward against those who have hands off, versus once you change the property, and I don't know if you're referring to even like, compulsory medical examinations where you have doctors that are touching people. I didn't understand that, and we didn't talk about it, and I wish I could answer that. So, I think we've covered everything. I think we covered everything, Your Honors. Unless you have any other questions, we would respectfully request that you affirm the trial court's decisions below. Thank you very much.
Thank you, counsel.
I wish I had more time, because this is a very interesting conversation. And I think that really we hit it on the head here. I'm going to go through some things real quick because I don't have much time. But I think we hit it on the head here when we said, here's some people, the Rain-Rains. They're not even from the United States of America. And they get a report by an engineer who came to their house, interviewed them, poked around their house, sat down, talked to them, and then wrote in what possibly could be going on with their house in their report. And then they get it, and it's presumed correct. Well, of course, yeah.
Therefore, what do they do in reliance upon that? Is the argument that they chose not to sue the insurance company in reliance on it, and now they're damaged because they could have sued the insurance company, but they didn't?
Yes. You know what? That is a theory. Obviously, we're not at trial yet, so we haven't fully developed all the lines of reliance that we would present to a jury. But I will say that you're absolutely.
Was that alleged? Is that the alleged reliance in your pleadings?
I think we pled with sufficient particularity. I mean, we pled, we're at the pleading stage here. We haven't even developed all of our discovery yet. We did.
Has the statute of limitations run on your ability to sue the insurance company?
What has happened is this.
Has the statute of limitations run?
No.
Okay, so they did not, there is not detrimental reliance that they chose not to sue the insurance company and now can't do that because they still can, right?
Well, first and foremost, that's a jury question, but number two, I've already explained the date of loss phenomenon. When you go outside of the policy period and the date of loss and you get away from it, the insurance company loves to make this argument, well, you're outside the policy period. How do we know? They even sue sometimes if they've been prejudiced. You know, you're assuming that these people are sophisticated. You know, everybody's so sophisticated to go out, oh, well, I'm going to go ahead and dispute this and I'm going to go hire me an attorney. People are not that sophisticated. These people know what these engineers know what they're doing. And the bottom line is, you know, I'd love to put, first of all, I would love to put disclaimers in all my work, and when people want to sue me for malpractice, I can say, hey, here's a disclaimer. That's against public policy. That doesn't wash. That doesn't wash at all. And I really, you know, I only have 34 seconds here, but I will say this, I think some of the comments that have been made here while opposing counsel was arguing, I think it hit it right on the head. I think it hit it right on the head. Just because there's other people to sue, why are these people immune? What makes them so special? They're not mere consultants. They're not mere consultants at all. We're not asking for some crazy expansion of the law. These are not trial experts. Of course, nobody would ever sue a trial expert. That's just not what they are. They're making false analogies. And we ask that you would reverse the trial court's decision and allow us to proceed forward.
Thank you, counsel.
Thank you.
The court will take its morning break.